What happened in that hearing room wasn't just another round of grandstanding on Capitol Hill. It was a direct confrontation over power, secrecy, and accountability, with names that almost never get spoken together in official Washington, Trump, Epstein, and the FBI. We're going to walk through exactly what was said, what was alleged, and what it means. And we're going to separate the theater from the substance, because the stakes here are extremely serious. First, context. Most congressional hearings follow a script. Members posture for the cameras, witnesses recite rehearsed talking points. Real information rarely slips out, especially when the topic touches anything involving Jeffrey Epstein, a convicted sex offender whose death and network of powerful associates have fueled years of speculation. That's why this particular exchange stood out. According to the transcript and footage, the session was originally scheduled as a closed-door intelligence briefing, the kind of thing that usually happens in a secure room with no cameras, no public audience, and very little transparency. At the last moment, Eric Swalwell reportedly pushed to make at least part of it public. That decision alone suggests he believed something needed to be said out loud on the record. Enter Kash Patel. For our purposes, what matters is not his political profile, but his role. A senior national security and law enforcement figure, appearing as the person responsible for decisions inside the FBI about classification and handling of sensitive files. For roughly 40 minutes, nothing remarkable happened. Senators and representatives cycled through questions about budgets, counterterrorism, and surveillance protocols. Patel gave the kind of cautious, bureaucratic answers we've all heard 1,000 times, crafted to sound cooperative, structured to reveal almost nothing. Then the subject changed. Director Patel, I want to discuss the Epstein files. In Washington, that alone is a line-crossing moment. Epstein's name almost never appears in open hearings, not because there's nothing to ask, but because everyone understands how explosive the answers could be. Careers, reputations, entire institutions could be implicated. Patel's initial response was standard. He referenced prior testimony, invoked classifications, and tried to keep things vague. Swalwell cut him off and opened a folder, not a prop, but, according to the transcript, a stack of marked documents. This is the core allegation Swalwell put on the record, that since Patel took over his role, dozens of documents in the Epstein files that reference Donald Trump have been reclassified or pulled back from anticipated release. Not all Epstein files, not all high-profile names, specifically those touching Trump. If that is true, and to be clear, it is an allegation at this point, not an independently verified fact. It raises two separate questions. First, why are those materials being treated differently from other Epstein-related records? Second, who ordered it, and for what stated reason? Swalwell's strategy in that moment was straightforward: move from allegation into documentary evidence. He held up what he described as an internal FBI memorandum, dated months after Patel assumed leadership, instructing a classification review board to fast-track a review of Epstein-related materials referencing current government officials or individuals connected to them. When due, in the Ratapal. That's bureaucratic language. But then he narrowed it. He claimed that 23 specific documents that had previously been cleared for public release were pulled back and reclassified, and that every one of those documents mentions Donald Trump. Patel denied knowing of any targeted reclassification aimed at a specific individual. Swalwell's implied response was that denial is incompatible with the paper trail I'm holding in my hand. Now, let's pause. There are 3 layers here you need to keep separate. Layer 1. What Epstein actually did. That is established by criminal convictions and testimony. He was a convicted sex offender operating a trafficking network. Layer 2, who else, if anyone, engaged in criminal conduct with him? That is still the subject of intense speculation, partial disclosures, and ongoing legal battles. Photos, flight logs, and social contacts are not, on their own, proof of criminal participation. Layer 3. How federal agencies have handled the evidence, who they have investigated, who they have not, and what they have been willing to disclose. Swalwell's attack focused on Layer 3. He did not accuse Patel of personally committing Epstein's crimes. He accused him of shielding specific information about a former president from public and congressional scrutiny. To drive the point home, he reportedly produced a summary of witness testimony, a woman employed at Epstein's Palm Beach residence who, he said, provided a list of men she claimed to have seen with underage girls. According to Swalwell, one of those names was Donald Trump. That is a claim about what a witness said, not a judicial finding. Witnesses can be wrong, they can lie, they can misinterpret what they saw. But in the context of a congressional oversight hearing, the question becomes, what did federal investigators do with that testimony? Did they investigate it thoroughly? Did they close it out? Did they decide it was unreliable? Or did they mark it classified and move on? Patel's response stayed within familiar guardrails. He would not speculate on classified material, he cited privacy and investigative sensitivity, and he denied any effort to shield a particular individual. From a strictly legal perspective, that's unsurprising. He is under oath, on camera, with lawyers at his back. But politically, optics matter. And the optics of a senior law enforcement official sitting under bright lights, sweating as a member of Congress, waves documents and accuses him of protecting Donald Trump from the fallout of Epstein's network, those optics are radioactive. Here's what this does not mean. It does not mean Trump has been criminally charged in connection with Epstein. He has not. It does not mean the FBI has admitted to burying evidence. It has not. It does not mean every document Swalwell referenced will stand up in court or survive classification review unchanged. What it does mean is that a sitting member of Congress has now placed very specific allegations about the handling of Epstein-related evidence involving Trump into the official record and promised subpoenas, inspector general reviews, and classification audits to follow. If that process actually moves forward, several things could happen. Internal watchdogs, inspectors general could examine who ordered which files sealed, when, and on what rationale. Classification review boards could be forced to justify why certain photos, memos, or summaries remain withheld. Career agents who worked the case may be asked, under oath, whether they felt pressure to steer investigations away from any particular names. Congress itself could seek access to the files in a secure setting, compare what they see to what has been disclosed, and decide whether further public releases are warranted. Will any of that happen? Washington has a long history of allowing outrage to burn hot for 48 hours before quietly reverting to business as usual. There is always another scandal, another headline, another crisis. First, the names involved. Epstein is already synonymous with elite impunity and unanswered questions. Trump is the most polarizing political figure of the last decade. Suggesting that federal law enforcement has handled Epstein-Trump materials differently from other Epstein records is, by definition, politically explosive. Second, the footage already exists. The exchange has been clipped, posted, remixed, and debated across platforms. Whatever happens next in Congress, the visual of a lawmaker saying to a senior official, "You didn't protect national security, you protected Donald Trump," is not going away. From a legal standpoint, the key issue going forward is evidence, not rhetoric. Are there, in fact, 23 documents that fit the description Swalwell provided? Were they previously cleared for release and later reclassified? Do they all mention Trump? And if so, what is the stated national security rationale for keeping them out of public view? Those are questions that can be answered with logs, emails, classification forms, and internal correspondence, the mundane paper trail that either supports or undermines claims of a cover-up. Politically, however, the battle lines are already drawn. One side will frame this as overdue transparency about how power protects itself. The other will call it a partisan hit job, weaponizing an old scandal to damage a former president. Your job as a citizen is not to adopt either narrative wholesale, but to insist on clarity. Who made which decisions, based on what rules, with what oversight? If the answer is yes, there is a double standard, then sunlight isn't optional. It's necessary. If, on the other hand, the documents and reviews ultimately show that there were legitimate investigative or privacy reasons to keep certain materials sealed, then the public needs to hear that explanation clearly, not hidden behind reflexive no-comment responses. For now, what we have is this: a viral confrontation, a set of serious allegations, and a promise of subpoenas to come. What we don't have yet are the documents themselves. Until we do, the responsible position is to treat these claims as allegations, demand rigorous oversight, and resist the temptation to treat any one hearing as a final verdict. Accountability, if it comes, will arrive one document, one Inspector General report, and one hard-fought disclosure at a time.